In general, what I want to say this morning is to turn to the question of what we might mean by saying, what are the implications of saying that in general, culture studies is a project committed to analyzing the changing contemporary conjuncture, and is still supposed to be self-reflexive about its intellectual agenda, as well as its practical and political objectives. So about 8 months ago, when Baden asked me to come to Kobe to speak about human rights, I thought about the journey that I've taken since around 1999 was the first time that my own education in human rights actually started, when I had the opportunity to work at Columbia University. I've been writing about human rights with the view that the global rights politics today desperately needs restructuring. That as a discursive construct, it is either in disrepair or in a state of massively disillusioning those who seek justice in this world. This is the problem about human rights. So I want to start there. It's a failure. It's a massive disappointment. So at this stage of the conference, I want to focus my talk on asking how thinking about law and human rights would affect the way we do culture studies, and vice versa, under this sort of conjunctural condition of failure. It's very clear in my mind that critics and theorists have very rarely put culture studies, human rights, and legal theory in the same room, or draw the same intellectual or political inference by mixing these things. What's more, the idea that culture studies might be described, those of us who are so proud of being in culture studies, the idea that it might be described as needing to open a space for a downright liberal paradigm of human rights, of laws and doctrines, is not one, in my experience, that draw great passions for critical minds. In fact, my experience tells me that to many in culture studies, this will be a very bad marriage. But more seriously, the fact is that the persistent mobilizations around issues of rights, with paradoxical effects on the strategies of anti-imperial politics on the one hand, or on education of critical legal methods and practices on the other, have not been seriously charted or assessed. Now, you may not be persuaded by the story yet, but that's my excuse for turning to a topic about which I know many people feel that, after all, what can usefully be said about culture studies as a type of political practice in the world has already been said far too much. I thought I would start by giving you my own definition about human rights. Now, I know everybody sitting here is doing work on human rights, whether you say so or not, whether you thematize it in your work or not, right? Anybody who sees the kind of state brutality, the kind of surveillance that's encroaching upon everyday life, the kind of discrimination and hostility against minority people, whether they're gay and lesbian or disabled people or whatnot. Everybody sitting in this room is doing something about human rights one way or the other, because this is what we're living through. I mean, we're living in the age of the end of human rights, the failure of human rights. So in many ways, everybody should have their own definition about human rights. This is just my own take, right? Given that I've been thinking about this for about a decade now, I call this the commitmentarian politics, right? That is articulated through legal practices across institutions, as well as social movements in civil society. Knowing full well that law and social movements are not always contiguous, and in fact could often be in antagonistic relations. But the antagonism between human rights laws and rights-associated social movement is precisely a necessary relation for thinking about the political reality of human rights. I also want to put up this little diagram, what I call the universe of rights. This is no shocking news to anybody, but again, I just want to put this out as the kind of working framework. Right? Running around this universe are these four major domains. And so I keep my eyes focused on these four. So whenever I take up a particular human rights situation or human rights case, of which I will talk about in a moment, because much of the remaining part of this talk is surrounding a particular human rights case that had preoccupied me since 2009. I looked at these four things: identities and communities, legal protection, institutions and social movements, and everyday and systemic oppressions. When these things happen and they're put in this particular kind of orbit, then I think it's time to call on human rights thinking, particularly for those of us who want to do cultural studies as a critical practice. I think I'll skip this following slide, what I call the DNA of human rights. I just want to put up the kind of things that are important for anyone who wants to study human rights, including some historical narratives of violence, moral philosophy, of course, legal theory. Sociologists would come in to say, well, let's not talk too abstractly, because human rights consciousness are embedded in our everyday life and in social relations. And of course, reforms in government and democracy. So in the end, the framework suggests that we're all sitting here enjoying some sort of rights. That's why you feel so comfortable now, right? Everybody feels rather comfortable because you are sitting on at least a dozen rights that you're enjoying right now. Taking any of these away, then you start to feel uncomfortable. But other than talking in these broad terms and definitions and stuff like this, I'm actually going to be much more specific. I want to talk about what I've learned about transgender law over the past few years in Hong Kong. I bother with the law just as I bother with the human rights system, discourse, and activism because of the law's profoundly complex relation with the formation of the legal subject, with institutional apparatuses working in the name of social justice, with political movements, like the umbrella movement, and cultural discourses. Ultimately, we cannot distinguish between institutionalized formal laws from everyday social norms. In fact, the assumptions made by law in many ways mirror and interact with the operations of social norms. You see, laws are so interesting because of the ways in which it produces a continuous cycle of double norming, right? First in the everyday life, and then in legal domains, and back. In the legal imagination, though, transgender persons are near illegible subjects. They are nearly an abject class. I say nearly because of the fact that transgender plaintiffs convey their injuries in the legal system that either doesn't recognize them at all or draws a line in such a way as to render them strangers to all of the laws that were supposed to protect them. I came to learn about transgender law first in law school 10 years ago, as I said earlier, and then through making friends with transgender activists in Hong Kong. One of them is Joanne Leung. This is the woman that's in the middle of the picture. She's a male to female transgender comrade. I currently serve as chair and Joanne as vice chair of a Hong Kong-based NGO for sexual minorities known as Pink Alliance. An important engagement of Pink Alliance as an organization is to participate in judicial reviews for sexual and gender rights. In 2009, in the midst of various campaigns you see in these pictures, we stumbled upon a court case that would prove to be groundbreaking in Hong Kong legal history in the area of gender and marriage laws. Miss W, that's her name. It's not Joanne, okay? Joanne is my friend. Miss W, we don't really know who she really is. I never met her. I am going to supervise a PhD dissertation in which this young woman claimed to have met her and interviewed her. She's a transgender woman. And a few years ago, she had this wild idea that she would marry her boyfriend, who is a biological male. This is in Hong Kong. Now, she was refused by the Registrar of Marriages. After that, she sought legal action in October 2009 in the Hong Kong courts. It became the first ever judicial challenge to the territory's marriage laws. I'd like to take this occasion to use the W case to reflect critically on the broader conjuncture of the transgender law nexus, and in turn use it to illustrate the possible kind of convergence for thinking human rights and cultural studies together. One of the central issues I wish to address is the prospect of decolonizing the transgender law nexus. in legal terms as well as in terms of broader cultural change. Now, before I get into the W situation, okay, it's a fascinating story. Some of you might think, oh, it's just about getting married. What's so shocking? What's so uncommon about it? Think again, the kind of marriage ordinances that regulate marriage in your own country, right? My guess is, vast majority of those of us sitting here are governed by laws that still operate in the largely Judeo-Christian tradition of articulating one man, one woman in exclusive relation, blah, 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 in those ordinances. Think about the challenge of that very mundane, common kind of understanding of marriage for a transgender person, right? Before I get into that, I want to frame this project on transgender rights struggle within a larger and longer-term project that I call the, what do I call it? The Legal Modernities and Rights Criticism Project. I just want to say how grateful I am to be able to share this bit of information with you about this project, which is the book that I'm finishing, in which I try to look at the intersections of cultural studies, law, and questions of modernity. Now, very few of us in cultural studies have taken the law beyond its normativizing impact on culture and life forms to reconsider it patiently, yes, and open-mindedly as an important sphere of determination for the making of society, politics, selves, and collective struggles. But I believe we need a project that looks at both the restrictive and potentially emancipatory capacity of law and of human rights legal history, theory, and practice more specifically. What we don't need, I think, are political teleologies that either celebrate unreflexively the so-called global age of rights or simply focus on the negative side of human rights and calling for its death. Personally speaking, I should tell you that no one in their right mind should be teaching full-time and pursuing a formal study of law in law school at the same time. I do not recommend this to you. Trust me. It isn't something that is fun. But if you think that the search for new experiences that can potentially reframe and transform your politics, and in a manner without teleological guarantees, is one way of doing cultural studies work, then a foray into something which cultural studies has largely stayed away from, that is, the domains of formalized institutional rules of engagement in general, and practices of a struggle over everyday rights in particular. These are the things that cultural studies have largely stayed away from. And if you believe that opening that up could be a way for you to do new critical scholarship, then you should give it a try and get crazy, right? I don't assume that, I should assume, in other words, that some of you have a law background, studied law, and whether formally or not, and you would know the torture that they put you through in that particular area of study. What do I come out of law school with? The way I see it now, law is a space of an acute manifestation of a modernity bifurcated between enchantment and disillusionment, between political possibility and instrumental dead end, between hope and despair. Spinoza, in his major work Ethics, calls for grasping the relation between law as arbitrary command and law as intuit knowledge and imminent embodied responsibility. Boaventura de Sousa Santos, one of my heroes in looking at the legal pluralist tradition, there's a brilliant book that he wrote, and it's come out with several editions, called Toward a New Legal Common Sense. He places law and the wider juridification of social practice on the side of emancipation in Western modernity, even as he cautions that this emancipatory role of law often arises as the double of social regulation. And then Ben Golder and Peter Fitzpatrick, in their book called Foucault's Law, recast Foucault's disciplinary thesis with the purpose of what they call thinking law otherwise, that is, of retrieving the restless responsiveness of law. So since about 2017, 2 years after I finished studying law school, in the program specializing in human rights law, I've begun to think about ways of overcoming the mutual blind spots, as it were, between culture studies as an intellectual movement and human rights studies as part of a global justice movement oriented towards law on the one hand and social movements on the other. I've begun to invest in a rather long-term project of theorizing together rights legal practices and rights criticism by investigating the multiple levels of activities in the social totality, where the vexed ideas of law, justice, rights, and movements have historically evolved alongside other equally vexed ideas of nation, sovereignty, citizenship, and moral universalism. This is why the four plenary speeches converge. And these are vexed contradictions. That's always the first door to open up. If you want to open up the door of human rights, you need to start with those vexed contradictions. Through working on a series of human rights legal cases over the years now, I've written about environmental rights, the rights of ethnic minorities. I've written a paper about the rights defenders in China in the movement, what they call the Weiquan movement. I've written about the umbrella movement in Hong Kong and this transgender marriage case, and I'm still working on other cases to enrich my own understanding and learning. I've become more and more convinced of the need to develop a framework for understanding what I call legal modernities. Not only the legal aspects of different spheres of modernities and interaction, but also the deeper, more historically and discursively oriented juridification of social and political practices across varied modernities. Unless we have a project on legal modernities that stretches vertically into histories and horizontally across apparatuses of law and movements, critical culture studies would remain mired in narrow and dehistoricized debates about the possibilities and impossibilities of human rights. So in this larger project, I'm particularly interested in jurist writings, changes in legal institutions, practices of legal pluralism, judicial activism, counter-hegemonic international law, and finally, legal common sense and social imaginaries in order to reframe the politics of rights. If you have time that we can interact a bit, I can tell you what these things are. I have no idea. I'm working on them. I'm reading a lot about these things. Okay. I hope to do so not from the normative, enlightenment-oriented northern vantage points, but neither should we denigrate or abandon the work by many groups who, through advocacy, education, social enterprise projects, and active dissent, have utilized and experimented on laws and skillful legal argumentations to kindle social movements for the struggle of rights, for rights, in the North as well as in the global South. No doubt, when we talk about legal modernities, we know there is a long history of legal transplantation that has led to the hybridization of legal traditions. One of the most exciting subjects, it's a module that I had in law school. But something else is going on. In our current moment, legal hybridization has achieved a degree of expanded vision and fluidity that has led not only to a decentering of Western legal hegemony, but also to a disaggregation of nations and their judicial apparatus as monolithic legal entities. Basically, what I'm trying to say is that there are many jurists and legal scholars writing today who have had to reimagine the sources of law, the arenas for making and disseminating opinions and judgments, including the internet, the modes and directions of legal referencing, the changing influences and even prescriptions by both religious and forms of secularism that underlie the writing of laws, the increasing significance of cultures and collectivities in the reconstruction of rights, so on and so forth. Some of them came up with some fairly creative ideas. For example, there's the notion called law without nation, rights without nations, or even rights without laws. These are some of the provocative ways in which the reflective jurists and legal scholars have proposed to mark the increasing complexity of legal modernities. In this light, my provisional definition of legal modernities is that it refers to the scattered but linked spheres of law-related and rights-inflected writings, institutions, apparatuses, movements, and forms of common sense. Then culture studies is one of these really nice disciplinary history that allow us to look at these sorts of complexity and articulations in the conjuncture. Underwritten by colonial legal traditions and representations, many of these spheres have nonetheless negotiated counter-hegemonic philosophies and practices, and have done so through legal pluralist declarations, strategic political pressurizing, and enactment of cosmopolitan laws. Human rights occupy a uniquely central position in this theorizing of legal modernities. I've said this earlier, that rights have either been glorified or denigrated, but one thing hasn't changed, and I hope you're with me on this page, that human rights have continued to powerfully transform our social imaginary. In the debates over new and old forms of citizenship and sovereignty concerns, in the renewal of collective identities and communities, in exerting impact on constitutional laws, various branches of economic laws, environmental protection laws, family laws, humanitarian laws, and so on, and finally in the construction of popular consciousness responsible for igniting social movements, ranging from the Occupy movement to the World Social Forum, the Digital Social Forum, the Jasmine Revolution, the South-South Forum, the Umbrella Movement in Hong Kong, so on and so forth. Now, there is no accident that just as many people are calling for the end of human rights, that the crop of these sort of multitude movements are popping up everywhere, right? There is a relation that we need to figure out still. So this is the moment to ask about these linked, right? Seem to be scattered, but linked kind of movements, many of which are using the rights language, even though we're so disappointed, by that system. So, let me go back to Miss W, right? Because I was like doing this whirlwind thing. Let me come back to the world as we do the real world. The case of Miss W's struggle for marriage rights, because it has reverberated widely in more and more jurisdictions today. Now, the final court's decision on W was handed down last 2013. So it's been a little bit. There's been a lot of time, and because it's so groundbreaking, that it started to reverberate in many jurisdictions today, effectively offering us an opportunity in culture studies to consider the nature and purpose of speaking of a post-colonial consciousness for the transgender legal subject. That is the deal, in the next 10 minutes or so. For that, I've had to outline an international trajectory of reform jurisprudence in transgender laws, in order to point out not only some internal legal inconsistencies, but also the opportunities arising precisely from those inconsistencies. Now, one of the nifty things about working with law, especially using the case law approach, is that you get to canvass the kind of, and look and examine the kind of internal inconsistencies in the law, and then find opportunities for argumentations, right? That's the fun part, that we need to learn not only the language, the protocol, but also the institutional spaces in which those of us who think of culture studies as a political practice should be able to engage in. I've written this out as a draft in what I call episodes, and this, I don't know why I call them episodes. These are not sections, these are just sections in the paper. I probably only have time. I was going to talk about a few, but let me go to episode 4. Okay, because that's the one that I think is probably most relevant to this crowd. The post-colonial queer encounter in law. I hope this might be instructive for those of us working in gender and sexuality as these things intersect with human rights law. It goes without saying that transgender cultures, identities, and practices vary widely in different national and local contexts. Anthropological works commonly cite profound diversity found in specific transgender identity formations in post-colonial social milieu, such as the Hydra or the Hydra in India, the Bradash in native North America, the Banshee or warrior in urban Indonesia, the Zenith in the Arabian Peninsula, the katoi, if you will, right, so what is called in Thailand. Although these are all glossed together under the rubric of the third gender, there is a strong precaution against Western homogenizing tendencies. In other words, there has now been a strong awareness in transgender studies to resist crude forms of nationalist and colonial imagination that work to flatten or essentialize the transgender existence, especially the existence of transgender people in the global South. One of the present questions for us here is this: how would queer theory, I noticed there are 3 or 4 panels on queer theory in this conference alone. Very exciting. How would queer theory, now of paradigmatic status and authority in theorizing non-normative identities and cultures, withstand its Western-centric orientation? Put more directly, how would queer theory, with its strong foothold in continental theories on the one hand, and mostly Western metropolitan experiences on the other hand, answer to its own underlying colonial impulse? Another pertinent question is this: how do we put queer and post-colonial theories into productive dialogue with each other, not as abstract theorizing, but in the actionable space of the law, such as in the case? The W case is one of the many similar occasions across the post-colonial world where legal reform for queers is increasingly significant and urgent, but politically contestative. So I was going to go through many different examples from Uganda and the Philippines and Jamaica, but I think I'll skip these and go to this part as my conclusion, perhaps. In the end, using the kind of ways of thinking that I'm developing, the framework that I spoke about in the early part of this talk, I think what we need is a theoretical triangulation among post-colonial, queer, and legal theories and struggles. So in the past 2 decades, there has been an emergence of what can be called queer reform jurisprudence. In other words, there has been a plethora of LGBT privacy and anti-discrimination laws around the world constructed through the court's recognition of variously sexed and variously gendered subjects. However, research of this queer reform jurisprudence has largely centered on the metropole, reproducing a global legal geography that refers again and again to the European, the American, or the Australian experiences. There's not much work in this kind of area out of the global South. Nonetheless, an important point I'm trying to make is that the post-colonial queer reform jurisprudence is slowly emerging, albeit with uneven results, to dismantle national sovereignty concerns, heteronationalism, and racism. I want to end by making a provisional inventory of 5 main sites of legal struggles in post-colonial context. First, struggle against lingering colonial anti-sex and anti-queer penal codes, the most enduring being Section 377, which had spread across the British Empire from Africa to Southeast Asia, and which remain today, you might be shocked to know, in over 30 countries today where the antiquated law, Section 377, is still used to harass civil society, restrict free expression, and discredit political enemies. Secondly, inter-movement solidarity, especially through an appeal to tolerance of gender and sexual diversity in the face of familial and religious strictures. For example, solidarity built around the notion of HIV compassion seems to be very visible. 3, deployment of a diffusion of norms model through transnational interjurisdictional referencing. Very fancy, but this is what the legal people do. Right? They do very good work, actually. I mean, what we often say, oh, let's do comparative collaborative work in culture studies. People in the law field has been doing this for many, many years. So they often utilize human rights instruments, the most prominent of which today around sexual minorities are the Yogyakarta principles. Some of you are familiar with that. 4, a coupling of the critique of conservatism in the state's sexual regime with the critique of the state's migration control regime. Right? This is such a fertile area of research. Right? When these two things come together, the regulation of sex and the regulation of migration, right? This is where all the troubles begin to intersect for queers and migrants and queer migrants and migrant queers. Right? And finally, epistemological realignment, chiefly involving a decentering of the understanding of queer existence in the legal field of the West. In these various sites of post-colonial legal struggles, the emphasis is obviously on thinking of law transnationally. This means simultaneously linking and separating the important set of binaries and dyads that structure legal awareness and practices. So this is the latest thing that I tried to visualize in my own head about how human rights and its socio-legal apparatus on the one hand, and culture studies, seen very much as an engaged political practice on the other hand, can be brought together in the context of political despair, but also in the same context where ethics, justice movements, and activism are being quite activated, especially I talked about in the last few years, and how these, in those contexts, the top two circles and the horizontal can produce what I really hope researchers would develop, right? Which is an actionable space. How do we make the right political choice for culture studies to turn it into something actionable, especially post-colonial actionable space? I was talking to Baden a little earlier. We need that critical mass. You don't need to have to go through law school. Trust me, you don't have to. You don't want to, right? But to develop a sense about how the role of law and legal consciousness in general are impacting the way that we do culture studies and vice versa, and develop some research agendas that can turn culture studies into real political choice, not only for ourselves, but also for our graduate students and for the people that we have come into contact with in our own communities, whether you're in NGO or not. There are many cases and many sufferings and torturing going on in your own community, right? There's no shortage of looking for these opportunities for action, right? And this is the space that I'd like to develop. Thank you for your patience. Yes.